Welcome, it's Pauline Polek and it's Legally Inspired. Today I will be discussing company law and incorporation and a separate legal personality. In relation to separate legal personality, in legal world, this is something as important as inventing electricity, so to speak. So it's something like really important and basic, and I will highly advise to know the subject very well. I will start from advantages of incorporation. So advantages of incorporation is separate legal personality, limited liability, transferability of interest, perpetual succession, common seal, floating charges, formation of large associations, favorable taxation scheme, Irish corporation tax, separate legal personality, a company, a legal person, regarded in law as separate and distinct from the identity of its members. So it's completely separate person, completely separate identity from the members. A legal status of a company means it can enter into contracts, sue on its own behalf, or be sued by other parties. Separated from its members by the corporate veil. The corporate veil may be lifted or pierced in certain circumstances to get at those controlling the company. Corporate veil, it's not a veil. It's like really solid wall. Seminal case: Salmon versus Salmon. And in my case, I would highly recommend to know the facts of this case. They are quite interesting, by the way. So Salmon was a boot manufacturer. He was a sole trader at the very beginning, and then Salmon decided to open a company. So he sold his business to his own new company. The company paid him for the business partly in cash and partly through issuing shares and debentures. Company became insolvent, and the creditor who held debentures given to him by vendor and secured on company assets makes claim against company. Company's liquidator refuses creditor's claim, and then it was decided that debenture was invalid as the company could not owe money to itself. The company issued the debentures. For example, it was the company's debt. Could vendor be pursued personally for the company's debts, even though he was original debenture holder? And the decision was made by the House of Lords. The company was duly formed and registered and was not the mere alias or agent of or trustee for the vendor, that the vendor was not liable to indemnify the company against the creditor's claim. There was no fraud upon creditors or shareholders, and the company, its liquidator, was not entitled to rescission of the contract for purchase. The sale of the business from the vendor to the company was bona fides in good faith. So as I said, this is a seminal case. It's very important and you should know the facts. And in my case, when you're answering the question, you don't necessarily tell all the facts of the cases. but sometimes when the facts are similar in problem question, then it would be good to mention the facts. Other than that, only briefly if you want, but the most important thing is what that case brought into law and why you are talking about that. so this is important once you mention the cases. Effect of corporate veil. Once all formalities of company formation complied with, company is legally distinct from its members. The case worth remembering is Roundabout Ltd versus Bernie. Fact of identical membership and directorship in both new and old company irrelevant, still distinct legal persons. So in relation to Roundabout Ltd versus Bernie, it was in relation to a bar was closed and the staff were picketing the premises. In the meantime, the director set up a new company to which the business was transferred. The new company only hired barmen who were non-unionized and hired them as directors. Since the new company had no employees, it could not be classed as an employer and thus could not be the subject of a trade dispute. Roundabout Ltd then sought an injunction restraining the picket, which was duly granted. Another case is Prest versus Petrodel Resources Limited and others. This is very interesting English case. It's not exactly a company dispute. It was a divorce case, and in this case, the husband didn't own the assets because all his assets were owned by the company. In the end, it happened that the Supreme Court, UK Supreme Court, unanimously overturned the Court of Appeal's judgment, agreeing that the corporate veil should not be pierced at common law. And it was decided that the assets were held by the company on a resulting trust for the ex-husband. Corporate veil can be lifted or pierced by a court or pursuant to legislation. Courts have deemed it appropriate to lift the corporate veil in certain circumstances by reference to principles of agency, single economic entity, illegality, fraud, misuse of the corporate form, minority shareholder protection. Agency. Relationship between holding companies and subsidiaries may give rise to relationship of agency, which may justify piercing of corporate veil of the agent. A test for establishing agency relationship set out if in Smithstone and Knight. Smithstone and Knight versus Birmingham Corporation. It was in relation to a compulsory purchase order. The holding company was entitled to the compensation, and in determining whether the company was an agent of holding company, the court had regard to the following factors: 1. Whether the profits of the subsidiary were treated as profits of the holding company. 2. Whether the persons conducting the business of the subsidiary were appointed by the holding company. 3. Whether the holding company was the brain and controlling mind of the subsidiary. 4. Whether profits were made by virtue of the holding company's skill and directors. 5. Whether the holding company was in effective and constant control. Another interesting case, which is worth mentioning in relation to agency, is Fives versus DCC. It's a very complicated case. I wouldn't mention a lot of facts, and I wouldn't really learn a lot of facts in relation to that case. Only the basics. I would say that the court held that the full factual scenario would be assessed to determine whether the subsidiary was an agent of the parent. Yes, I would mention Firestone Tire and Public Company versus Llewellyn. I'm not so sure if my pronunciation is correct, and sorry about that. Single economic entity. I would mention DHN Food Distributors Ltd versus Tower Hamlet LBC. This is the seminal case in this area. DHN had two wholly owned subsidiaries. One owned property, conducted business on that property, occupying under a license. The defendant local authority compulsorily acquired the land, and the plaintiff sought compensation for disturbance. The land tribunal offered negligible compensation. The Court of Appeal held that the group of companies should be treated as a single economic entity and secured full compensation. Another case would be Adams versus Cape Industries. Another case, Polypack International PLC. I would also study Power Supermarkets Ltd versus Cromlin Investments Ltd and state McInerary and Company Ltd versus Dublin County Council. Again, I'm not so sure about my pronunciation, and I'm really sorry about that. Allied Irish Coal Suppliers Ltd versus Power Dufferin International Fuels Ltd. I would mention this case, and next one, Rex Pet Foods Ltd versus Lambros Island Ltd. Fraud or illegality. They may be lifted in order to identify companies which have been created or used for fraudulent or improper purpose, and the case would be Jones versus Lipman. They has been lifted where a separate company was incorporated so as to obtain a subsidy not available otherwise, and this is FG Films Ltd. Minority shareholder protection, where a company has been set up in order to avoid protections or remedies available to a minority shareholder that they may be pierced, and the example case would be Bugle Press Limited. Company could not rely on separate legal personality where it had manipulated a takeover by a new company created by the same officers that would otherwise have been prevented by the minority shareholders' refusal to agree to the initial takeover bid. Lifting the veil by legislation. Examples can be Section 49, failure to maintain company name properly, Section 1010, so Section 1010, failure of PLC directors to obtain certificate to commence trading, Section 609, director's liability for expenditure during insolvency process. Section 610, reckless trading. Section 599, related companies' obligations to contribute to payment of debts or to pool funds. Section 600. Section 293, recognition of group company arrangements, for example, subsidiary undertaking. So I think that this is mostly what you should mention in relation to separate legal personality. I highly recommend to know the subject very well for the exam, for FE1 exam. I hope that you like my lecture. If you do, please give me a thumbs up. I have a Facebook discussion and support group which is called Legally Inspired. I also have a TikTok profile, Legally Inspired. And if you would like to connect with me on LinkedIn, I'm Pauline Polik. So please do connect, please do sign up to my Legally Inspired accounts. And thank you very much for watching. Thank you. Bye!